Hello everyone. In this video, we are going to discuss about the applicability of GST in case of freight charges, either in case of ocean freight or air freight, in case of import and export. And also we'll discuss about the availability of input tax credit for the recipient of those services. So we'll discuss about all the situations where the freight is either paid on CIF basis or on FOB basis and what are the implications of GST on that. So let us see the first slide. In this slide, we are going to discuss the situation where the service provider is located within India. That means the shipping line or the custom housing agent who is charging on own account. Custom housing agent not charging as a pure agent but charging on own account is in India, or the shipping lines or the airline company, whoever is charging directly to the customer is located within India, right? Now we are discussing two situations, import and export. First we are focusing on export. In case of export, the freight can either be paid by the exporter in India or by the recipient outside India. Now a recent circular has been issued where the freight is paid by the exporter in India and the service provider is located within India. This circular is circular number 184 by 16 by 2022, dated 27th December 2022. This circular clarifies the applicability of GST, nature of tax charged and the availability of ITC. Let's understand this. First of all, we need to be very clear that up to 30th September 22, there was no GST where goods were carried from the customs clearance station in India to outside India, that is in case of export, right? Except in case of mail and courier where GST was there, but other than mail and courier, up to 30th September it was exempt. Now, from 1st October, GST has started to be levied on such kind of charges. It has been specified very clearly in the clarification given by the government that from 1st of February 2019, there was an amendment in the place of supply provisions. The place of supply provisions says very clearly that if supplier is in India, recipient is also in India, but the destination of goods is outside India, in that case, place of supply will be the destination of goods. So, where the service provider here is in India, exporter is also in India, place of supply is outside India because the destination of goods is outside India. So, in such cases, even though service provider and recipient, both of them may be in the same states, even though both of them are in the same state, still IGST would have to be levied. And the place of supply has to be shown as foreign country. So service provider will show the IGST as will show the tax as IGST, and foreign country will be the place of supply. Now a very big area of litigation since then has been, particularly in case of mail and courier. Now from 1st October, even in case of cargo services, because the exemption has been removed, is whether the area of litigation is whether ITC would be available to the recipient. Mind you, there was no restriction in the law which debarred one from taking ITC under this case. Under this gamut, they have issued this circular that if the service recipient is in India and destination is outside India and place of supply is also outside India, there is no restriction in the law for availment of ITC. That's why the ITC can be availed even though the place of supply is not the home state, right? So this is a very big area of clarification, because till now we had been under the impression that this would be a very big area of dispute, because the government may say that the place of supply, since it is not the home state, that means where the recipient is located, ITC might be called into question. But with this clarification, a huge area of litigation now stands to rest. Freight paid by the recipient outside India. So where the freight is paid by the recipient outside India, it would be considered as export of services. Service provided in India, recipient of services outside India. If all other conditions of export of services satisfied, it will be considered as export. All other conditions basically include that the payment should be in convertible foreign exchange. It should not be merely establishments of distinct persons, all those cases. Import. Now where service provider is in India and we are talking about import of goods. Freight is paid by the supplier outside India. So we are talking about the supplier if he is outside India. In such cases, once again, service provider, since he is in India, POS would be considered as the destination of goods. Destination of goods in such cases would be considered as India. So in such cases, service provider would have to pay CGST, SGST in India, right? This is in cases of other than mail and courier, simply because the place of supplies in India, right, which is the destination of goods. For mail and courier, it would be considered as export of services because the service provider is in India, recipient is outside India, POS is also outside India. Talking about freight paid by importer. Service provider in India, importer is in India, destination of goods is also in India. In such cases, service provider will be charging to the importer and he will be charging taxes based on the location of the recipient. If the location of recipient is in the same state, he will charge CGST, SGST, otherwise he will be charging IGST. Mind you, this is applicable only in case of ocean freight. As of now, air freight is still exempted where the import of goods is happening from outside India, right? So in case of air freight, this is still considered to be exempt in nature. Next, we are talking about where the service provider is located outside India. In such cases, we are talking about export and import. In case of export, where the freight is paid by the exporter in India. So service provider outside India, recipient within India. But once again, POS is the destination of goods. So in case of export, the destination of goods is outside India. RCM, import of services, is only applicable where service provider is outside India, recipient is in India, and the POS is also within India. But in this case, the POS is also outside India because the destination of goods is outside India. Mind you, in case of mail or courier, destination of goods is not the place of supply, it is the location of recipient. So location of recipient, which is the exporter, is in India. That's why it would be considered as import of services and the mail or courier has to pay under RCM. Next, in case of export where the freight is paid by recipient outside India. Here the service provider is also outside India, recipient is also outside India. So in such cases, there is no implication of GST whatsoever. Next, in case of import of goods where the service provider or the shipping line is outside India. Now, where the freight is paid by supplier outside India. If the freight is being paid by the supplier outside India, the Indian importer does not receive the services. But the GST law required the importer to pay taxes under reverse charge. This got challenged before the Honorable Supreme Court in case of Mohit Minerals, and the Honorable Court ruled that the recipient is not the importer of services. It is rather the person paying the freight. So the person paying the freight is the supplier outside India. So there cannot be any tax implications on the supplier outside India. So on the importer, there should not be any reverse charge applicable. So that's why through this judgment by the Honorable Supreme Court, the taxability on the importer was quashed, right? Next, freight paid by the importer in India. If the freight is paid by the importer in India, in that case, if it is ocean freight, then supplier is outside India, recipient within India, importer is also within India. That's why we would have to pay under RCM in respect of ocean freight. For air freight, the services continue to be exempt wherever the import of goods are taking place through air. Those are still exempt. So there would not be any implications of GST on that, right? In all the cases where we have talked about the applicability of taxes, the ITC would be freely available to the recipient if he is registered. So there is no issue altogether in terms of availment of ITC in any situation. Whether the POS is outside India or within India, it does not matter. For the recipient, ITC would always be eligible if he has made the payment, of taxes, right? So with this, we come to the end of this video. I hope you have liked this video. Thank you so much for giving me a very patient hearing.